Meaning 50. Bombay, the medical system. What is the but that medical and that police so about the evidence that he is admitted at the Bombay. એટલે હજી નામદાર પર પરમિશન આપશે પછી હિન્દુજામાં ખાલી લેવાતીમાં બેમાંથી એકમાં you are asking your report there ના રિપોર્ટ નથી કર્યા સર પણ ત્યાં બે જગ્યાએ વાતચીત ચાલે છે કે નામદાર કોર્ટ પરમિશન આપે પછી ક્યાંથી અપોઇન્ટમેન્ટ બેમાંથી એકમાં જ લેવાની છે સર એટલે નામદાર કોર્ટ પરમિશન આપતું પછી ક્યાં દાખલ કરાય એવી પૂછતી નામદાર કોર્ટ requires some things that to avoid treatment is used for that hospital. So what time he required hospitalization? એ તો હવે ત્યાં લઈ ગયા પછી એમની ટ્રીટમેન્ટ કેટલા ટાઈમ સુધી ચાલશે એ તો એ કેનો કેટલા ડોક્ટર કેમ છે આ ડોક્ટર કેમ છે પણ એ પણ સાહેબ એ એકચ્યુઅલ ફાઇનલ ના કે અઠવાડિયું ટ્રીટમેન્ટ ચાલશે કે 10 દિવસ ચાલશે ના ક્રિટિકલ સિચ્યુએશન છે એટલે what do you mean by critical? Where is the life? એમને બ્રેન સ્ટ્રોક આવેલો છે સાહેબ એની ફર્ધર ટ્રીટમેન્ટ માટે ત્યાં લઈ જવાનું some range for the under the treatment at the hospital? No, right now he is not in the hospital. ઘરે જ ટ્રીટમેન્ટ ચાલુ કરી દીધી ગાઈડન્સમાંથી હવે ત્યાંથી રિલીઝ કરી દીધા અને અહીંથી હવે આપ નામદાર કોઈ પરમિશન આપશો પછી ત્યાં હિન્દુજામાં અને હિન્દુજામાં અને ત્યાં બે વાતચીત ચાલે છે કોકિલામાં એટલે એ બેમાંથી એક જગ્યાએ લઈ જવાનું. One thing is very much clear. Don't say that if court permits them, they will go. If you are required, your condition is critical, you might be right. But it should be supported by some document. Is that support document? If Child's Hospital has released you, then under what impression we should believe that further treatment માટે super specialist માટે ત્યાં લઈ જવાના છે. Then there should be some reference. You are required to take treatment outside of this and that hospital. Discharge જે ગાઈડર હોસ્પિટલનું જે બધું જ રજૂ કરે છે વેર ઇઝ ધેટ ડિસ્ચાર્જ ડોક્ટર અજીત મારા ભાઈ પેજ નંબર કોને કયા પેજ 19 નંબર મારું ટાઈપ કરેલું 19 નંબર છે એમાં બી સાહેબ 11 બી જે ટ્રીટમેન્ટ ચાલુ છે એ ટ્રીટમેન્ટ લખી લીધું બી કન્ટિન્યુ કરીને એની પાછળના પેજમાં બી 20 નંબરના પેજ ડિસ્ચાર્જ સમરી છે ના ડિસ્ચાર્જ સમરી એની પાછળ સાહેબ મારું જે કરેલો 25 નંબરનું પેજ This is normal discharge. પણ ટ્રીટમેન્ટ ચાલુ છે એની 24 નંબરનું પેજ જોશો તો બી સબ છે આગળ ટ્રીટમેન્ટ કન્ટિન્યુ ચાલુ છે દવા અંદર ઓબ્ઝર્વેશન that you are continuing since last year you are continuing your treatment at your home. Now you could point out the emergency situation. You are telling critical, but on what basis you are saying critical?
Document હોય તો
then why did you file and why did you mention yesterday also? Now, where is that criticalness? Don't try to create an impression as if you are coming that every heaven is going to fall upon you.
No, sir.
Then where is your discharge is normal, your Zydus hospital
further treatment માટે જવાનું
But you
એટલા માટે જવાનું
you point out from the record that yes, you want to go there, you have consulted there. What is there that you have
એક
consulted?
ડોક્યુમેન્ટ રજૂ કરતું
Then where was the urgency? Why didn't you put that document?
ત્યાં હજી નથી એ લોકોએ કર્યું ત્યાં હિન્દુજામાં એમાં કે પરમિશન આવે પછી જ અપોઇન્ટમેન્ટ લઈએ સાહેબ એટલા માટે છે ફર્ધર ટ્રીટમેન્ટ માટે છે.
You are an advocate.
Yes, sir.
You know the court procedure. This is not the first brief. So you should know when you are making a submission of criticalness, when you are coming to the court before filing, showing the utmost urgency, at least verify the fact by some documentary.
Keep that, my lord.
I will not go there and examine the patient. I am not an expert of that field.
I will do.
Simply making your submission and very nice sentences as if entire heaven is falling upon you right now. And then you say that if court permits, then only he will go. Where is that criticalness? Yesterday you made a submission, and therefore I passed the instruction to the registry on your statement. Now, where is there a single document that you're, on the contrary, your Zydus hospital has discharged you as a normal condition? But then
document produce કરશે sir.
If you don't have answer, then please say that, sir, I don't have answer on this.
Right now I have no answer.
Then I am rejecting your application.
Instruction લઈ 10 મિનિટ પછી આપ નંબર કરો.
We are not here to that you come at any time and start.
મેડિકલ ટ્રીટમેન્ટ છે એના અગેન્સ્ટ બાકી તો ફેક્ટ્સ જે છે એ છે.
You don't have a single document about your critical illness and you are making a submission, whole statement before the court to this is the very smart way of advocacy. When nothing is there, then you show the entire criticalness. Where is the criticalness from your document? And then you want court indulgence in an extreme emergency situation. You are not a newcomer.
I know, sir.
Merely because the status, that does not change the, at least have some passion, some responsibility on your shoulder to show. And then you are, your submission is so very much crafted. If court permits, then we will go. Court never wants that patient who is requiring a urgent situation that he should be prevented. But
relevant document.
You are relying upon your discharge summary which shows that normal discharge. What answer do you have?
ફર્ધર ટ્રીટમેન્ટ માટે જવાનું.
Where is the further treatment?
પણ એ નથી લીધી હજી ત્યાં જઈને.
અરે you should have been advised by some expert doctor. Your treatment is required and it is
એવું કઈ એડવાઇસ આપેલું છે એના કોઈ ડોક્ટરે તો એ સર્ટિફિકેટ રજૂ કરશે.
And this prevents the court to interfere. The advocate are coming anytime and mentioning about urgency.
Not anytime.
Yes, yesterday you came.
Yes, my lord.
Now what was this urgency?
आज મેડિકલ ઇમરજન્સી છે my lord.
તો ક્યાં છે આમાં?
હું એ રજૂ કરી દઉં છું 10 જ મિનિટમાં. મારા જે ડિસ્ચાર્જના સમરીના પેપર છે, મારી મેડિકલ ટ્રીટમેન્ટ છે તો ઓલરેડી મેં રેકોર્ડ ઉપર રજૂ કરી દીધેલા છે. હવે ફર્ધર મારે ટ્રીટમેન્ટ માટે જવાનું છે. એ નામદાર કોર્ટ ગુજરાત હદની હદ છોડવા માટેની મારી અને one
line argument and the order would have been passed. Had you placed proper document on the record of the
પ્રોપર છે. હવે આગળના આપ નામદાર કોર્ટની જે ક્વેરી છે કે મને જેટલા કાઈ ક્લાયન્ટ
proper sir.
એમની મેડિકલ ટ્રીટમેન્ટ ચાલે છે.
Now I am putting you a question. Your documents are proper. You show me that your condition is critical. Right now we'll decide it.
Not critical. એટલા માટે જ હું 10 મિનિટમાં ડોક્યુમેન્ટ જે બી પ્રોડ્યુસ કરશું.
You take your own time.
Okay.
We will not at your convenience.
No, my lord.
When you fail to produce document when your chance was available, we show indulgence in every matter considering humanitarian ground, and then you take everything liberty. You don't bother to rely on
first time, my lord. This is first time after bail.
But then why don't you place the record?
No, my lord said so many times this is first time, my lord, after bail કે આ ક્રિટિકલ સિચ્યુએશન છે એટલા માટે જ આવેલા છે સર.
But then also you are not understanding or you don't want to say Page number 1, page number 25.
Yeah. Taking time.
Yes. then I think that's nothing. Then if I think just take just to decide to cover it. Number set is a visit therapy, condition. Exam one of that is not take undue advantage of the liberty of misuse the liberty. વિદ્વાન મિત્ર કહ્યું કે 3 ગુના ચોક્કસ દાખલ થાય ત્રણેયમાં એલિગેશન આ ગુના સાબિત થાય આ ત્રણેય ગુનામાં નર્મદા કોર્ટે બેલા પણ આપેલા no doubt those are anti-incident but not as true. બીજું reason છે it shall mark his presence before the Samsung police station every morning Monday between 11 to 5 for 6 months. આ ઓર્ડર નંબર છે 2023માં 6 મહિના સુધી તેને હાજરી આપવાની. પ્રોસિક્યુશન પણ કહે છે કે એક વખત જ એમણે હાજરી આપી
ત્યારે અમારું ચોક્કસ એવું કહેશે કે દરેક કિસ્સામાં હાજરી આપવા ગયેલા કેટલાક કિસ્સાઓમાં હાજરી નોંધ કરી નથી એવું લાગે. પરંતુ 2023ની વાત છે. આજ સુધી મારા ઉપર એવો કોઈ આક્ષેપ નથી કે આઈ હેવ ટેમ્પર્ડ વિથ એવિડન્સ ઓફ ધ પ્રોસીડિંગ. 2023ના 6 મહિના સુધી વાત પૂરી થઈ ત્યારે 26ના આવી બિલ કેન્સલેશન આ ગ્રાઉન્ડ પર થવામાં આવે. આ કિસ્સામાં સાહેબ કેટલાક મેં સાઇટેશન પણ રજૂ કરેલા છે. રિટર્ન આર્ગ્યુમેન્ટ પણ આપેલા છે. ઓપ્શનની પરવાનગીથી રેલિવન્ટ પાર્ટીમાંથી.
But what about condition number 7?
Objection.
What about condition number 7 of the order?
For years, they have filed the cancellation.
We will, your contention that for 6 months marking presence condition was of year 2023. The honorable court order was of 2023.
Yes.
That condition number 7 is very specific. If you
Automatic.
breach any condition, then your bail will cancel automatically.
He was present.
Then you saw, you point out, yes, you are present.
He has marked his presence. But
Your say can't be accepted. Your mere say.
that was the account of police station. Okay.
The police has maintained the account. You can't shift your concern, your contention of that you have marked present. You can't shift that responsibility upon the IO. The IO has come with a case that you have not marked the present.
But Your Honor, that was the discretion of police station, okay, to mark or not to mark. I am coming with the case. Okay, I have marked my
And
presence.
then you point out, yes, I was there.
Yes, sir.
Under what basis? You may come with any case. Your say is not to be believed gospel truth when the prosecution has alleged that you have breached the condition.
But evidence is
You are not for trial.
but evidence is there, sir. But I am saying that I have marked my presence on every.
But then your say must be justified by something. Your mere say won't work.
I have no evidence
Then how can it be believed?
because they secured the evidence of the marking.
Right.
Accused is going to the police station and they mark his presence.
You are an accused of receipt of offense, familiar with the proceedings of the law.
Right. Yes.
Then you are very smart. You could have kept some evidence if you are apprehending. No, I have told that my presence is not marked.
એના પાસેથી evidence આવે ગાડી મોકલ્યો છે બસની ટિકિટ
ગાડી ગયો હોય તો ફોટો પાડી લે ને હું ત્યાં હાજર છું સાવર લોકેશન હોય તમારું
આજકાલ પૂછી જોઈએ
એની પાસે ન જ હોય ને બ્રિજ કર્યો એની પાસે ક્યાંથી હોય હોત તો તમે આપી દીધું
આપણે અને એ વાત સાહેબ 23 ની છે કોઈ ટેમ્પરિંગ કોઈ કર્યું નથી એવિડન્સ સાથે
ટેમ્પરિંગ યુ નોટ એન્ડ ટેમ્પરિંગ યુ હેવ ઇન્ટરવ્યુ નજર ઓપન
ઓકે પણ માય મીઠું છે કે આઈ માર્ક માય પ્રેઝન્સ ઓન એવરી each and every occasion.
Similar type of FIR has been registered against you.
It is anti-incident. That is only allegation, not proof till date. And in this regard, many judgment I will સત્યના ધ્યાનમાં ઉપર છે ઘણા ચુકાદા ધ્યાન ઉપર લાવું છે. પરમિશન આપો તો મેં મૂકેલા છે આપણે લીધું. One of them is a Renew versus State of Punjab.
You are also a prosecutor.
Please.
When the prosecutor then you would have said, let him, that it is his responsibility to do, okay, yes, mark his presence.
So,
and the police has marked your presence once. It is not that the police have except malified against you.
there's no tampering. It's about the Manav Mao, but there was no tampering because the state is complete. Because the state is complete.
Where no, state is not the complainer.
In Kuchi court,
It would by default police would be there because he would be the officer
yes.
Sending the proposal for invoking restriction.
Same suggestion, connect to High Court Gujarat case છે કે આવું કર્યું હોય તો that was no reason for cancellation. Hospital for 5. violated the relevant part. I'm reading. In case the reasons have been mentioned while granting bail, it cannot be cancelled only on the ground that a number of FIRs were registered against the accused, and he managed the statement of the complainant. It is necessary to be seen as to where any complaint has been made by the complainant or the other party who was witnessed in the FIR registered against the accused, that the compromise was effected with the ulterior motive have been putting under pressure upon the witness. It has also been observed in the various judgments that the court does not interfere with an order passed while granting or rejecting the bail to the accused, but it is equally necessary to be seen by the court to exercise its discretion judicially, cautiously, and strictly in compliance with the basic principle laid down in the number of decisions rendered by this court or the Honorable Apex Court. It is also well settled that not only the circumstances but other factors are necessary to the borne in mind while considering an application for bail. Furthermore, sir, I know I like it. In our સિદ્ધાંતો લખ્યા છે કયા સંજોગોમાં બિલ કેન્સલ કરવી છે. એમાં લખ્યું કે the scope of this power to the High Court under Section 439/2 has also been considered by the Honorable Apex Court in the case so and so. And એમાં એનો 16મા પેરામાં લખ્યું કે કયા સંજોગોમાં બિલ કેન્સલ કરવાના. Furthermore, next statement says પ્રભાકર
જે ગ્રાઉન્ડ લઈ શકે પેલું જ ગ્રાઉન્ડ છે.
હા એના વિશે પણ those these grounds are illustrative and not objective.
હા તો એક ગ્રાઉન્ડ તો આપણે કન્સિડર કરીએ પેલું છે. misuse his liberty by indulging criminal activity.
But those are allegation only. Those are not all. Those are anti-incident, but these are not proven till date. An honorable court has granted the bail. और एक दिशाમાં પણ છે હું આપણે પ્રભાકર પછી નંબર 3 પ્રભાકર તિવારી was state of Uttar Pradesh. There is a statement of Honorable Supreme Court. Relevant part 1. There are several similar cases pending against the accused. However, such factors by themselves cannot be basis for the refusal of prayer for the bail, and a holistic view has to be taken of all facts and circumstances, as has been done by the High Court in the present case. According to the order of the High Court granting bail stands sustained.
So it was pertaining to grant of bail.
The same case. No doubt there is a distinction between the rejection of bail and cancellation. પરંતુ નંબર પડતો વ્યૂ હતો કે ફાઇલિંગ ઓફ એન્ટી ઇન્સિડન્ટ those are not grounds for the rejection of bail. બીજા આ લાઈન અમને ચૂકાતા સમય જશે. કેમ કે વાત એવી કે આ દિન સુધી કોઈ એવું ગ્રાઉન્ડ નથી બન્યું કે એક્ઝિસ્ટ હેવ ટેમ્પર વિથ ધ એવિડન્સ. So this is a humble request.
You were granted bail in receipt of offense.
Yes, sir.
There is provision of twin condition also. Therefore, stricter the provision and the stricter condition there is of the offense.
Did I move to what condition? This application.
You don't even mark your presence. You don't mark your presence. Police is liberal upon you, that they don't immediately come to the court.
After 3 years,
They are liberal upon you for reasons known to them.
એ કારણ હું કહેતો નથી, પરંતુ તમે એવું કોઈ કારણ નથી કે અમે પુરાવા
Then you continue to indulge yourself in other offenses.
બીજી બે છે
Same argument.
નહીં એમાં એક જ ગ્રાઉન્ડ એન્ટી ઇન્સિડન્ટ એમાં માર્કિટ પ્રેઝન્સનું નગર હાઈકોર્ટે કહ્યું.
So in his case, presence is marked by the police.
Only the condition of marking the presence is 1145 જિલ્લામાં માત્ર એન્ટ્રી
Therefore, in that case, police is not mala file. So in co-accused case, police is mala file.
એવું નથી કેવું પણ એમાં હાઇપોથેટિકલ કન્ડિશન કે નોટ ટુ ઇન્ડલ્જ એની સેવિંગ
And you indulge. You have indulged.
No,
You want to place anything on your record to show you that you have even mark your presence?
I'm trying.
If you are heard now, if you find anything, then you can say it.
Great.
પેલું લખેલું હશે ને તેની રીત ઇસ્લામના ઉપર.
Here I'm at 70-52 Popal police station. I am starting around. Here I'm at 70-52 major service. Applicant owner Rajibai Sunani. Popal police station is there.
First seek the permission of the court. Yes, sir, I am starting with this way. Now you can decide that you will which letter. First seek the permission. You can't say that, sir, I will start with this letter.
My apology. Popal police station માટે સાહેબ હું 23/2/2026 ના રોજ સાહેબ એફઆઈઆર નોંધાય બીએનએસ સેક્શન 316(2) 316(5) 61(2) 35 સેક્શન 3 ઓફ સીપીઆઈડી. What is my role સાહેબ? કોલમ નંબર 12 વાંચ્યું છે. એવી રીતે કે આ કામના આરોપીએ ભેગા મળી પૂર્વ આયોજિત કાવતરી વચ્ચે પોતાનો સમાજ
તેમાં કોલમ નંબર
12 ઓફ ધ એફઆઈઆર મારો. યસ
Yes.
એનેક્શન એ મારો.
પેજ નંબર એ કહી દો ને.
પેજ નંબર 3 મારો ઓફ ધ એફઆઈઆર
અને સિક્વન્સ માં તો એ 17 નંબર.
કોલમ
મને ઈઝી પડે વાંચતા. Yes.
Can I start?
Yes.
તે એવી રીતે કે આ કામના આરોપીએ ભેગા મળી પૂર્વ આયોજિત કાવતરી વચ્ચે પોતાનો સમાન ઇરાદો પાર પાડવા કેશવ નારાયણ ગ્રુપના નામે છેલ્લા ગામ બ્લોક સર્વે નંબર 24 ડ્રાફ્ટ કાઉન્સેલિંગ સ્કીમ નંબર 3 ફાઇનલ પ્લોટ નંબર 24 અક્ષર અનંત નામની સ્કીમ મૂકી જેમાં 14 માળના કુલ 14 બ્લોક એબીસીડી બનાવવાની વાત કરી 2 BHK તથા 3 BHK ફ્લેટ દુકાનનું વેચાણ કરાવવાનું જણાવી ફરિયાદીને વિશ્વાસમાં લઈ ફરિયાદી પાસેથી સ્કીમના 2 BHK ના બી બ્લોકના રૂમ નંબર 803 બુકિંગ પેટે ₹1600 અમાઉન્ટની ફરિયાદી અને ફરિયાદીના મિત્રો કાયદો ખાતમરી કેશવ નારાયણ નું આઈડી CS બેંક એકાઉન્ટ નંબર 7 મેળવી ફરિયાદી એક સમજૂતી કરાર. That is the point out, my lord. કરી આપી જેમાં રેરા આવેથી બહાના કરી આપવાનો તમને જો ફેટ રાખવાનો ન હોય તો 2 વર્ષ સુધી 1600 અમાઉન્ટ વ્યાજ સાથે પરત આપવાનું વૈષમ્ય લોભાવની સ્કીમનું લખાણ કરી આપી. I am applicant of Keshav Narayan, director, partner director. Ronak Rajibai Sonani. The co-accused, there is other applicant, my lord, Vipul Gangani, my lord. Both are the partner, my lord, of the Keshav Narayan group. સમજૂતી કરાર કરીએ તો FIR ના નામે છે. That is the matter of the civil dispute. આ કામ ફરિયાદીને સાહેબ સમજૂતી કરાર કરી આપ્યો છે. That is the point, first point, my lord. There is a delay of the FIR, my lord, 2.5 months, my lord. ફરિયાદી જોડે સાહેબ જે બી ડિસ્કશન થયું છે
આ કામના ફરિયાદી ઉમેશભાઈ ધીરુભાઈ સાથે જોયેલા સાહેબ યોગેશભાઈ ઠક્કરે સાહેબ ડીલ કરી છે. There is
Okay. I rejected the application of another four persons. You were your agent.
yes my lord, exactly my lord. But સાહેબ વસ્તુ કેવી છે કે MOU સાહેબ થયેલું છે બધા સાહેબો જોડે. ચાર્જશીટ ફાઇલ થઈ ગઈ છે my lord. This has been registered before this honorable court. Other matter માં સાહેબ આ જ વસ્તુ છે સેમ છે my lord. Therefore
Keshav Narayan.
કેશવ નારાયણ, yes exactly.
You are the partner.
Yes, I am a Keshav Ronak Sonani and Vipul Gangani. TCB police station, Bhopal police station, my lord.
I have not considered for anyone. So you collected the money for a scheme. Then you did not return, you signed the MOU.
MOU
You the pledge.
MOU કરી આપ્યું છે my lord. There is a civil, there is a other remedy my lord. MOU સાહેબ થયું છે સાહેબ એનો વિશેષ અમલ કામ છે. Civil other remedy.
Now there is written decision also, the honorable effect. Under the umbrella of civil dispute, the court has also to look whether there was any act of criminality or not.
But there is a
Now after starting a scheme, if there was a dispute, then it would have been another issue. Your construction has not started, there is delay in construction, then you are right.
exactly my lord.
But exactly, after starting the scheme, under the guise of starting the scheme, you collected huge amounts from various people who wanted to purchase a 2 BHK, 3 BHK flat in Ahmedabad. Not only that, you did not completed the scheme, you did not return the money,
But
you sold away the land to other people, and that too without a single rupee of consideration. You are so generous.
but
For
MOU is
both
not
you.
expired my lord.
You are so generous for your four of you. Here, you executed a registered deed, mentioning that you have paid the amount of consideration through RTGS, but not a single money has gone.
MOU સાહેબ હજી એક્સપાયર થયું નથી my lord.
And
The MOU
you think that it's
validity is not expired my lord.
But then why did you sold the land to your co-office worker only? Why have not considered for your agent also? How many people? See,
In Bhopal FIR there is a 7 people.
how many?
7 people.
No,
As the accused my lord, as the accused person.
how many victims are there?
90 to 94.
So 92 in this case. You know, everyone has a dream to get a house in metro city.
But after you file સાહેબ investigation has been completed my lord. સાહેબ હવે આ કેસ ટ્રાયલ નો થઈ ગયો છે. ટ્રાયલ નો સાહેબ ડિસાઇડ થશે. Therefore my lord.
I am not considered for the co-office. You are the main partner of this.
Yes, I am both the partner my lord. Vipul Gangani and Sonani my lord.
Sorry. So in all matter same argument.
Same argument.
He is the
Police
partner.
station ખાલી અલગ છે my lord. Jurisdiction is different my lord. But I am also partner of the Keshav Narayan group my lord.
How many victims in all the 4 FIRs? કેટલા છે? ચારે ના થઈ total કેટલા victims છે?
સાહેબ બે ગુનામાં છે સાહેબ
બે બીજા partner છે. બે ગુનાને થઈ કેટલું છે?
ભેગા થઈને સાહેબ TCB પોલીસ સ્ટેશનમાં સાહેબ 64 જેવા થાય છે. 64 around my lord. And Bhopal police station 92 my lord. As per the police affidavit my lord.
So almost 150 people. આપણું વાહન તો કરી જાય ને પોલીસ વાળા કોઈ ટેન્શન થઈ જાય.
મારું એટલું જ પણ સાહેબ MOU therefore sir
You are right, but હા you return the money. ચલો.
એના માટે તે બહાર આવીએ તો કંઈક અમે કંઈક કરી શકીએ therefore.
When you were outside, you created a mess for yourself.
Because I have filed a temporary bail application for the engagement of the advocate earlier my
That is rejected.
also rejected my lord.
So See, now that your rejection is justified because you can engage advocate while you are in jail also for filing your regular bail application. રોકી તો લીધા તમે.
ચાર્જશીટ ફાઇલ થઈ ગઈ છે, ટીસી નંબર આપ સબની કોર્ટમાં ચાલે છે.
હા, અહીંયા GPID છે એટલે અહીંયા જ ચાલે. ક્યારે ડિટેક્ટ થયું? ડિટેક્ટ ક્યારે થયું? કેટલા ટાઈમ? પૂછી જોજો એમને હમણાં ડિટેક્ટ થયું છે કે કેટલા ભાઈઓ છે? એક જ છે. અત્યારે બેન ક્યાં રહે છે? એટલે એમના મધર ક્યાં રહે છે? ફાધર છે ને? with police જાપ્તા one day with police જાપ્તા એક વખત મળવા માટે લઈ જાય, પાછા લઈ આવે. He is not able to take medical treatment there. You are right. Yes. No. એટલે આપણે પોલીસ જાપ્તા સાથે જ મોકલી સવારથી સાંજ 3 કલાક. હા, જાપ્તાના પૈસા ભરો તો પછી વધારે દિવસ આપશું. હાજર જ કરવું પડે ને સર. તમે તપાસ કરાવી લો ને પછી ચોથા સ્ટેજ નું છે અને તપાસ કરે કે ખરેખર ક્રિટિકલ ને એવું જ છે. હોસ્પિટલે પૂછી જવો ને કેવી હાલત છે. On humanitarian ground with police jabta for certain hours.
360.
Humanitarian ground. And he will furnish the, and except he stay at the hospital, he will not, for how much time will relax with condition? 15 days.
15 days.
ચાલુ કરી ચાલુ કરી
And other than this, it has been alleged that he has regularized the government land to give legal purpose.
You are arguing the first complaint or second complaint? Second complaint.
And the second charges has been submitted, which has been accepted and given the CC number as 9/2025.
So you are arguing CBI special case number 9 of 2025. That is the second complaint filed by you.
Your Honor, the whole incident starts from
So second supplementary case is based on the allegation with regard to
Your Honor, here 3 persons who are raised by Vishnu by Bankar and Ramesh by Lakshmi by Bakwana. There are 3 persons who have prior to this requested the breaker to return. And by application, they have requested to regularize the land in the position. Your Honor, at that time, the collector have rejected their application. After that, they have approved the procedure of officers have also rejected their application. After this, Your Honor, they have approached Honorable High Court. And Honorable High Court have given the decision on 11th of December 2017.
So what is your complaint? First, let me take that he has argued on the last occasion. Okay, it was the matter was remanded. The case was asked by the High Court to reconsider. So you don't need to. So now, what is your complaint in the supplementary charge? Where is your complaint? Just show me from the record.
That is the first complaint, Your Honor, in presence of first complaint, and other than this, Your Honor, there are 3 executive complaints. I would like to tell you. It has been cited as Your Honor, 60, 61 and 362. The complaint has been specifically made by Suma Rai Patel, who was the member of Parliament.
That was the first complaint. This complaint.
This, Your Honor, India is probably Your Honor, 7,700 complaints लगभग. उसमें से जो substantial complaints थी, उस पर आयोग ने हमारे act report किया और 3 specific complaints, 360, 361, 362. ये तुम्हारा की complaints थी और इन complaints की basis पर applicants से सुरेश भाई लक्ष्मण भाई मकवाना, किशोर भाई वंका और रमेश भाई लक्ष्मण भाई मकवाना इनके अगेंस्ट कोई वेरिफिकेशन स्टार्ट किया. This regularization of land better related. Your Honor, in this context, the aforementioned applicants have applied to director on this. On 1st of January 2018, this application was regarding the regularization of enforcement upon non-resident Europe. In furtherance of
I want to know, first, there was one complaint. We are not touching that complaint right now. Now your supplementary charge sheet. Now for this supplementary charge sheet, it was in continuation of the first complaint. First one.
it was, Your Honor, in this case, in other first complaint, IO have investigated, Your Honor, more than 20 state complaints.
Now we are concerned with this.
Therefore, Your Honor,
First complaint was filed. So this was in continuation of this matter. So now in the first complaint, whether there was allegation of these three people being given the land at a lesser price or it was not there,
I have a-
which when earlier.
there were 4 dates of first complaint. First complaint.
એને
has
ત્યાં
been
રાખ્યો ને
made-
બાબા.
First complaint has been made by additional secretary government of Gujarat. Your Honor.
Hmm.
In that complaint, he has told that following are the heads under which
So that was the first charge sheet was filed on 2022 in the year 2022. And thereafter the second complaint has been filed.
yes, Your Honor,
A second charge sheet has been filed
yes,
in 2025. So I want to know whether the supplementary charge sheet, which is filed on the basis that some land was allotted.
that is.
Now, whether that allegation was forming the part of your earlier charge sheet, because your say is that it was the, this is in. So now this would be second FIR or it should be continuation of the first FIR? First FIR. So there should have been the allegation of this supplementary charge sheet also. So-
Then, Your Honor, in such complaint, I have not report that that in such complaint, there was allegations against.
Now don't make that submission in earlier I have submitted and earlier I have submitted. It has been long time. So now you point out, this is the supplementary charge sheet, whether the allegation in this supplementary charge sheet was forming part of the first charge sheet or not,
Your
whether it was kept pending for investigation or not.
It is not forming the part of first charge sheet. Your Honor.
It was not, but there was, you see, when you are making a supplementary charge sheet, that means you have continued the investigation of the first case.
Yes, sir.
Now, on what basis you have filed the second supplementary charge sheet? If this allegation in the second supplementary charge sheet were not the part of earlier complaint at all, or whether it was part of earlier complaint.
Yes, Your Honor, it is the part of earlier complaint. Because I
This
have-
allegation was the part of first complaint?
Yes, Your
Yes.
Honor.
Please point out where it is.
Yes, Your Honor, yes, it's the charge sheet. For third and fourth, Your Honor.
Now, where is from this charge sheet? Can you please point out? Point number 2 and 3.
3.13, Your Honor. And in light of that complaint, point number 3, Your Honor, and in reference to complaint, there have been cited there in 60, 61 and 62. The complaints have been made Why the mobile is investigation has been conducted and the result has been submitted.
Okay. So now this supplementary charge sheet is filed for the second and third number of allegations. And so it is to be believed that the first charge sheet was filed.
Also, Your Honor, this charge sheet has been given, or explanation has been given by the IO for other points. Point number 4 after.
So the case was registered on May 2022, first case. Thereafter, the charge sheet came to be filed in year 2022. And after 3 years of investigation, now the second complaint came to be filed, supplementary charge sheet came to be filed, whereby you have found some evidence about allotment of land by accepting some illegal gratifications. Yes.
As I have committed earlier, that it is related to business. On 11th of December 2017, where Honorable Head Court has directed to the applicant to approve the appropriate authority with collector. And it is, and their merit shall be reconsidered. On the regularity ordering of that direction, applicants have approved the collector office. And on 1st January 2018, requested the collector with regard to regularization of enforcement account was to be lined by them, imposed by them, Your Honor. Your Honor, in furtherance of this application, the collector of filed later dated 9th of May 2018, directed on Ahmedabad, who have submitted his report on 10th of May, next day, Your Honor. And specifically, Your Honor, in this report, Ahmedabad have pointed out that I have enclosed Roach count with this report. Other than this, Your Honor, those persons are in possession, and those persons or applicants, they do not have agricultural land. Other than this, they have also submitted that they are ready to pay the amount of fine.
We'll continue after next.
But
You have both the final report with you. First complaint and a second, first charge sheet and second charge sheet. Now it is on the basis of same FIR. It is based on the same FIR. Same FIR. Have you verified it? Confirm. Ask your IO. So the supplementary charge sheet FIR is of the year 2022.
On first,
There are reference of two. Your first charge sheet has the number.
In paragraph 12, 15.2, the original traffic. Point number 1, it has been written that regarding the Mother farmland. The other total of direct management traffic has been which has been numbered as 3 of it. And on this is what to run investigation I have related and as you mentioned, submission of report.
Yes.
You know that is one person the very important activity created one and remaining other two activity persons applicant have presented application report. Subsequently, collector office has directed the Ahmedabad to present a report relating to this application and the request of the alleged applicants. Ahmedabad has presented the report, out of which your honor, point number 5. It has been essentially that process of allotment of land question the foreign department is currently undertaking. And another thing is, your honor, point number 2, point number 3, there is no agricultural land which have clarified that those persons are not farmers. Subsequently, your honor,
So what basis you have said that this land can't be allotted to the non-agriculturists? On what basis? The Mamlatdar has given the report.
Mamlatdar has given report and the engineering authority, which are chiefs and your honor, resident additional collector, RAC. Have also agreed with that report.
So on what basis they have formed that opinion that this can't be allotted to?
Those opinions have been forwarded to the collector. And after that, after the review.
Mr. Either you are not understanding or you are not having. I'm asking that those authority Mamlatdar chiefs have given a opinion. So whether their opinion is binding, their opinion is correct or false. When you are making an allegation that this opinion has been ignored knowingly, because opinion is one thing, government resolutions or notification are different thing. My opinion, if it is not supported by law, then it is not an opinion. It can't be relevant. So your say is that this land can't be allotted to a non-agriculturist. Now on what basis the Mamlatdar has stated he should be having something. Okay, this is the settled position which has been knowingly ignored by the accused. So we have objected. Their opinion is immaterial. If we are talking about the opinion, then the collector would be the head of the district. His opinion would prevail upon everyone. We are not going by opinion. Now, when they have given an opinion and some order has been passed, now you have investigated the case and you have said this was intentional ignorance of the opinion. So mere ignorance of opinion is one thing. Mere knowingly ignoring the opinion which is based on some law, some provision, that would be a different thing. Now, which is that settled law?
I will state.
You tell, right now you tell.
That is drafted section 54 of
What your investigating officer has investigated. He has found that this was knowingly ignored. So mere ignorance of opinion of subordinate by a higher authority.
of the opinion of subordinate officials. There is something more than this.
But first, I ask you tell me that there was an ignorance of the opinion. Now, whether their opinion was right or wrong.
So, their opinion was
right. Okay. So who will decide that his opinion is right or wrong?
All the facts are being submitted to the honorable court, and honorable court will decide that.
I am not going to decide the revenue jurisdiction. I am to decide the discharge application. Now you have put a case.
Court has been for that. Other than this, Your Honor, there are certain facts which are required to be submitted.
Are you going to reply to this question? The court wants to know, you have charged a person of certain offences. They have raised a contention. They have taken every contention. First thing, he as a collector was the authority of that district. Now, if you are saying that a Mamlatdar who is far much in hierarchy, lower in hierarchy, whether his opinion would be binding to this collector, being the head of the revenue for that district, then there should be some provision of law, some notification or instructions of the government. Now, whether your investigating officer has found, yes, his opinion was ignored, though there was a some statutory provision or government instruction, you just point out that.
Just the security that is provided under, it is governed by, Your Honor, GR 1980, Your Honor.
Where is that GR? Yeah.
In GR 24, Your Honor, it has been provided that.
You point out, I want to read that GR. Where is that? It should be in the charge sheet papers. You're not having that. You can ask your IO who is here. You can ask your IO who is here.
Sir, the GR is in my compilation.
Let him.
But it is GR 1980.
पहले पूछिए उनको ऑडिबल है. Yes, please.
GR 1980, it is cited in this.
Yes.
As the
S.
D, you know.
Stand down and हमारी बाजू जाओ. Sir, what is your good name? Audible. Sir,
Yeah.
okay. So the first allegation that the accused had ignored the opinion given by the Mamlatdar and Chitnis and RSC while allotting the land to these three persons.
Yes.
Okay. So now, on what basis your investigation revealed that that opinion was supported by some law or some by instruction of government or not government resolution?
So as per welfare ordinance.
As per?
Given by welfare ordinance. So the opinion given by Mamlatdar, RSC and Chitnis. All the opinions are in consonance with the provision of welfare ordinance.
Okay.
And that is why I am saying the collector was bound to follow the opinion of Chitnis, RSC and Mamlatdar. Because their opinion was based on the
Sauras Gharkhed.
Yeah, 54 of welfare ordinance. But collector, in his note sheet, though he did not agree to the opinion of the Mamlatdar, RSC and the Chitnis, but he has not mentioned a single line of the justification why he is not agreeing to the opinion of those three persons, despite the fact they have mentioned right the reason that these persons are non-farmers, and because of this reason, they cannot be allotted. Their land, their enclosed land cannot be regularized. Why I am saying this, because the ordinance clearly says that the transfer of land is barred to non-farmers. Means through any justifiable reason, by sale, by mortgage, or any other acceptable reason, if any land can be given to someone else, that is not possible for a person who is a non-farmer.
So now,
Here,
yes, can you point out under which provision of 1954 Saurashtra Garkhed,
yes,
whether it is forming the part of charge sheet?
yes, sir, it is 54, sir, and I'm taking the D number, sir, which D number is there, sir, I'm telling you.
It is D54.
So it is 54, section 54 of Swaraj Garkhed ordinance, sir. And the D number of the document I'm just providing.
Saurashtra Garkhed છે. SH. SAU RS Saurashtra SAU Saurashtra SAURASH. Nothing.
Sir, D104.
D104 is the letter something, letter written to, okay, that is by the joint secretary.
If you see that, sir, this is 760 pages, sir, 760 pages. So I have enclosed, sir, all the relevant GRs and acts and ordinances, what is relevant in our case, sir. So it is part of that particular case.
So where is that page? Can you please point out, because
Yes, 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 sir.
that relevant page, so that we can go through it.
Yes, sure, sir.
D54 figure. Saurashtra Garkhed માં ફાયદો છે, વિદ્યાર્થીઓ છે. So yes, what have you prepared anything by the time? No, no, not argument about.
Yes, sir.
No, no, you are searching the page.
Sir,
Please do
yes,
it.
sir, I'm satisfied with this,
Have you gone through this provision? You can continue with, you can just tell me the page number.
Sure, sir. I will note down the page number. So actually, it is 54, section 54 of the Garkhed ordinance. Means it is available on online also, sir. Find this to reach the particular page.
Page number.
5. It is not from provided from the. There is no such permission that we granted to that is the point of which we have relied on. That the person from other sources still 5,000 rupees because it is with others. And that is the basis of this. I would like to point out ground boundary. This is the border this platform.
So this is not the.
Given on board of our regulations. First point is as to the violation of section 54 of Government or Ordinance Act 1966. Why is the this thing, Corona? Yeah, on its first point.
So this is page number 238 of E104, sir.
230.
238, sir. 238 of E104.
करके नीचे. Whether this land was falling under the Saurashtra Garkher ordinance?
Yes, sir. Yes, sir.
So on what basis you are saying that it was falling under the Saurashtra Garkher?
Sir,
See, what is you are relying upon the Saurashtra Garkher ordinance of 54.
yes, sir.
So while making the land applicable under the Saurashtra Garkher, it should be a land falling under the Saurashtra Garkher ordinance only. Now whether
Sir,
the
yes, sir. But our matter falls under this act only, sir.
it is your say, so I want to know how it falls under your this Saurashtra Garkher. Because there might be number of lands.
Sir, our Sudhir Nagar falls under Saurashtra, sir.
But even it is not merely a Saurashtra Garkher ordinance is with a particular object.
Yes.
So we would be also governed by the Bombay Land Revenue Code also. Now Gujarat Land Revenue Code.
Yes.
There
sir.
might be
Yes.
number of act ordinance which would be governing some portion of land, some part of land. Every land would not see because it is name designated as Saurashtra. Every land would not fall under Saurashtra Garkher.
Sir, but our Sudhir Nagar area, sir, it falls, means all provisions of Saurashtra ordinance are very well applicable on Sudhir Nagar business.
But I am
This is,
telling.
means it is a fact, sir. Means,
Sir,
and this act is applicable to our Sudhir Nagar area, sir.
Sir, you should have verified that this is the land falling under the Saurashtra Garkher.
Sir, means I have recorded the statements of the revenue officials, sir.
Yes.
They also cited this reason. They also cited this reason that because of this section 54, the land cannot be given to a non-farmer. I can show the statements of the witnesses also, sir. I can.
But the witnesses would be this chitnis, mamlatdar and so and so.
No, sir. They are revenue officials. So they are sitting in the Gandhinagar. They are not. Means they are minimum at the level of undersecretary. At ADM, additional district magistrate.
Can you give the name or that number of that witness who has said this?
Yeah.
Yes.
Yes.
कौन सा है?
Sir, this is a witness of PW40, sir, Hitendra Patel. Hitendra Patel, sir, PW42, sir.
Yes, what does he say?
Sir, he says that because of this provision, the land cannot be allotted to a non-farmer, sir. I have recorded a detailed statement. These are some joint secretary land reforms, Revenue Department handling. So even in the beginning of his statement, sir, he says that the Swaraj Garkhed agency settlement and agriculture ordinance deals with the settlement of dispute between landholders and their tenants and their matters. And it basically deals with the issues of land held by an individual. And after that, sir, he explains the sections. Then he comes to section 54, where he clearly says that because of this provision, land cannot be allotted to a non-agriculturist. And PW41 is also there, sir. Again by potential. He the deputy secretary land revenue department, sir. He also quoted this provision, sir.
So can you now read the para 2 of that statement of PW42?
PW42, sir, it is started since beginning, sir.
Yes, yes. So that's the second paragraph. On being asked, second paragraph.
Second last, yes.
Yes, so please go through it. No, not second last. The second paragraph.
Second last. Second last paragraph, sir, PW40.
Yes, PW42, second paragraph.
Sir, he started saying about the ordinance.
Yes, that is what we want to know.
Yes.
It deals with certain. Yes, you can also go through it. Go through this. No, I'm asking your APP.
Yes.
PW42. Yes. I'm asking you read the second paragraph. Don't read your convenient. Page PW42, first page, 20th May 2024, and second paragraph.
On the environment, state that the Swaraj Garkhed and agricultural ordinance with the settlement of dispute between the landowners and their tenants and other matters. I basically deal with the issues of land held by the individual.
So what does it say? That Swaraj Garkhed deals with the dispute between the landholder and their tenants. So now, whether this was a case where there was landholder and tenant, that you will have to show now. Yes, have you gone through it? Because you'll have to show that it was a land which was governed by the Swaraj Garkhed. And then you will have to also point out whether his application was under Swaraj Garkhed or not. Because it deals with the landholder and the tenant. The first basic necessity would be this. Then the next question would come, even if you are right, then who would be the authority to consider that issue, whether it would be falling under that or that. And then you will have to also show the evidence whether this was intentional done with full knowledge to commit the offense which you have charge sheeted him. No, you will have to, right now you will, because you are so eager, no? So now just we have to point out whether it would be governed under the Saurashtra Garkhed or not. Yes. So one thing is section 54 and you are relying upon the witnesses who have said this.
Sir, on the basis of section 54, I am saying that the land cannot be given to a non-farmer. Through legal means through purchase, sale, mortgage, or any other means which is permissible by law. I am saying this thing. So I am only saying, sir, if any land which is barred to a non-farmer on the basis of section 54 of the Garkhed ordinance through legal ways, then how a non-farmer, how a person can acquire a land through legal means? If it is not permitted through legal means, then how can a person acquire the same through illegal means? Then this is very easy for a person, sir. They simply go and encroach some government land and then they will go to the collector office and they will apply for the regularization of the encroachment. If it is allowed, sir, then this will be a clear way for any person who is a non-farmer, who don't have any agricultural land in his name or in his father's family, anybody else. He will simply import the land and then he will go for the regularization. It will defeat the very basic motive of our legal system, our legislature intents. So I'm simply saying.
I'm just, we are not arguing here. I'm just putting a question on what basis you have formed the opinion that he has committed the crime, because revenue proceeding would be one thing and criminal proceeding would be one thing, another thing. So now we are considering the discharge application, even if the legality of that order, even while.
Absolutely, sir. For one even if, sir, on the application of encroacher, I am ready to review their application, whether it is whether I can allow it or I don't allow it. Because I forget he's a farmer or not farmer. So simply I am saying if encroacher has come to the collector office.
Sir, we are, you just say, we are, let me be very clear to you, collector. Because Saurashtra Garkhed also has got its own another proceedings by which the order passed by any of the authorities can be challenged. So now whether passing an order, because collector would be required to pass every order under his jurisdiction. Now the court has to consider whether it is right or wrong order without any motive or whether it was intentional.
Yes, sir. Sir, if you allow me, sir, 5 minutes.
No, but let me, I will allow you not 5 minutes, I will give you 5 days. But first, let me understand on what basis you have formed an opinion that this is an offense.
Yes.
So when you rely upon section 54, first the application should be under the Saurashtra Garkhed Act. The land should be falling under the Saurashtra Garkhed dispute. So that is required to be seen, and then only we can say whether it was right or wrong. Even I, sitting as an deciding discharge application, won't have jurisdiction to decide whether his order was right or wrong. But since you are relying upon section 54, it would be required to consider. Because his other authority is other who will decide whether his order was right or wrong. Neither you, neither I can at this stage decide. I can decide his criminality.
Yes.
Yes. Okay, so you are relying upon section 54 and the statement of the revenue authorities from Gandhinagar. Yes.
Shall I go?
No, now your counsel would be arguing. Just I wanted to know.
Right.
By rejecting the opinion given by the audience office, collector officer has written a letter dated 19th of May 2018 to applicant again to the collector office, and on that date, which is 12th of June 2018, collector have further matter. Collector have decided to go for regularization. Your Honor, that is a second principle of law that is closer to the remove the difference of that particular land. they can only regularize the condition of excessive hardship. For that very purpose, to become that purpose, collector is required to that particular place where you spend that place. No kind inspection have been carried out, and after that, when collector have decided on same day to go for regularization, the matter has been forwarded to DN50. District labor evaluation, where rates have been decided for compensation, which has been decided as rupees 25 per square meter. It has been quoted that collector has the competence to regularize the land up to 2 acres. Or, which amount to be 2 lakhs, maximum. That is the maximum limit. Your Honor, while the rate has been calculated on 25 rupees per square meter, Your Honor, the total amount which has been required, which has been directed by collector office to be paid by applicants, that is 2,02,350. That is 2,350 rupees more than the competence of collector. Your Honor, this letter has been issued on 2nd of January 2019. Sorry, Your Honor. This letter has been issued on 7th of January 2019. In reply to that letter, Your Honor, applicants have reapplied before the collector office. By letter dated 16th of January, within 10 days, Your Honor, they have applied before the collector office. The person who has sought the regularization for land of 2 acres. Within 10 days, Your Honor, they have reapplied before the collector office that no, we are not competent to have that much land. We are having lesser money, and that's why we require some certain short area of our requested area, Your Honor. Ultimately, Your Honor, in reference to Your Honor, their data.
So your content,
16th of January.
on the first occasion, the land was allotted, regularized,
Yes,
which was beyond his competence.
yes, Your Honor.
And thereafter, that letter was also forwarded to the applicant. And then he made an application to reduce the land,
Yes.
so as to bring that land within his competence.
Collector office.
Hmm.
Your Honor, that particular area which has been thought by which have been requested by an applicant, which is 2 acres. Which is worth rupees to that 2,350. The matter would be forwarded to the Revenue Department for approval. And up to rupees 2 lakh, district collector was completed. At that time, they have requested to allot 1 acre and 38 hectares of land. One more has been prepared, Your Honor.
So the press application was filed. No.
Application furtherance of that letter which has been forwarded by collector office to deposit that particular amount in treasury. Collector office has sought rupees 2,02,350.
So that letter was sent to the applicant. Thereafter, applicant made another application. Yeah, I want this much land only.
And I don't require that particular that much land, and that's why reduce it. And in furtherance of Your Honor, that later area has been reduced. That is 1 acre and 38 hectares. First rupees, Your Honor, 1,97,250 rupees.
Yes.
This letter, this whole letter was issued to around 25th of January 2019. And the condition of payment has been verified on 13th of February 2019. Your Honor.
Yes.
Where it has been verified that the amount has been deposited, and after that order has been passed for regularization. Your Honor. That is our case, Your Honor. Because there are certain points that are required to be implemented in the control. Which I also firstly, collector officer collector have violated. Collector has ignored the report of subordinate serving officers. Now that is our first case. Other than this, Your Honor, there are no motions, but only one case has been fixed for hearing the applicant. No notice has been made, Your Honor, on same day. They have decided to go for regularization. Another is, Your Honor, no side inspection has been made. Your Honor. Other than this, Your Honor, another submission is no clarification has been given why they have not visited the site, why they have not given a notice, and why they have decided to go for regularization. Another point which is required to be that is reduction of area. Reduction of area. Why area have reduced only to extent of only 2 months? Only up to the extent of only around 5,000 rupees. Your Honor, other than this, Your Honor, in the report of Ahmedabad, it has been specifically mentioned that land is being processed for transferring to forest. Department of Forest, Your Honor. This point has also been reported, Your Honor.
Then was process for,
Forest Department. Your Honor.
where do we get that?
In Ahmedabad report, Your Honor, on point of files has been stated. Another thing is, Your Honor, prior rejections. Prior to this, Your Honor, the same applicants have applied before the collector office and they have not decided to go for regularization. That's a prior rejection.
Now, where is that Mamlatdar letter that land was processed for forest?
Ahmedabad report, Your Honor, that is given 54.
G?
Given 54. I will reconfirm with Your Honor, but from a very report, it is given 54.
G1. Okay. G. G. G.
Given 54. 150.
એ તો રેશન કાર્ડ છે. This is something ration card.
Your Honor, then I will clarify. Your Honor, my last,
Don't go to last. First tell me where is this. When you are making a submission, try to point out. Your submission will not bring your case. When you are saying that land was processed for forest,
Your Honor, the report of Mamladar have been specifically mentioned on page number 73 of our charge sheet.
કયું ડોક્યુમેન્ટ છે ને આપણે ચાર્જશીટ છે ને આપણે તો એને આમાં બી હશે ને. Yes, now where do you find this?
If you honor on point number 5, the topic of the law of land is the forest department is currently.
જમીન. So then you would have collected this, whether any proposal was there.
Yes, sir. They have collected this, but it has been cited as a code item. I will.
You tell me the document number.
Definitely, I will.
Yes, then.
Now I'm coming to the ground. On which citizens have found out this was. Firstly, absence of violation of section 54 of Garfield ordinance.
I also wanted to know what is the evidence.
Yes.
So on the next date, you may come prepared before you deal with the grounds. One, your contention. Okay, this was not within his competence to allot the land. Secondly, he was non-agriculturist. Third, he intentionally lowered down the area. And same day the application was decided. And at that time, if any correction was to be made in the earlier order, then it should have been gone through the committee. He alone could not have done it. And then the land was, the proposal to allot the land to the forest department was in the way. And this whole thing has been intentionally ignored. And therefore his order is bad.
And another thing they have
Now,
not.
come prepared on the point also. He has been charged under section 13 and 13 of the PCA, apart from 409(120) of the IPC.
Because he has committed an offense.
First, listen to me. Prepare yourself. Suppose we prima facie, if it is found that he was not competent to allot that land to a non-farmer, then also the basic ingredients of PC Act should also get attracted when you are invoking the provision of PC Act. So prepare you with your IO. Yes, even if that order, because every authority would be having, would be passing an order. Maybe his Mamlatdar, maybe his Talati. His order may be right and wrong, challengeable before the higher forum. That itself cannot be a ground. Otherwise, no one would be passing such order. Because he is, by the statute, he is given the power to pass the order.
Yes.
Many orders, every collectors.
I do understand.
So then you will have to point out, yes, this was intentional, this was the conspiracy, and for this consideration, these orders have been passed. Okay.
Your Honor, we have to- That's very, I would like to say that as I have stated earlier. Collector office quite later dated 19th of July 2018. Fixed the date for hearing on 12th of June 2018. On that particular date, yes, heard and decided without inspecting the particular place where encroachment have taken place.
But that was already earlier part of the, now the application which he has decided was already decided by the consultation of the committee. He ignored the report of the chiefs and Mamlatdar. And here,
They are making it, Your Honor.
Ah.
They all have reviewed, they have asked, they all have stated that, regulation could not be made in favor of.
that are their opinion, there are their objections, whatever.
I will understand that collector was not wrong. They have-
No, he may pass an order ignoring those directions, or ignoring those opinions. Then his order can be challenged. Now, when you are prosecuting a person for the PC Act, then the PC Act ingredients should be attracted. That you will have to prepare yourself.
For that, with the clarification. that,
I don't want clarification now. I want the evidence which you have collected.
Your Honor,
You will have clarification, not evidence. Who says that yes, this was for some ulterior motive, for some consideration? Because no one would do a favor without undue favor. So how, under what impression your IO has gathered the evidence, that you will have to point out. What loss has been caused to the government when you are charging for 409? One thing. Secondly, what are the ingredients of PC Act?
Because Your Honor, the alleged accused person have committed an offense under section, 300 and, section 360 clause 5, Your Honor. By being a public servant, he has, committed the criminal breach of trust, Your Honor. Then he has given that particular land to be.
Sir, you saw the from the charge sheet papers. Yes, this witness is saying okay, he took this amount, therefore this order has been passed. You just point out from the charge sheet. I don't want commentary of Mr. Gyan Singh.
Okay, Your Honor.
Point out from the evidence. I can't go beyond here. I will go by the evidence. You can certainly discuss with your IO and say, okay, sir, these are the witnesses who have said.
Give me half an hour.
Why half an hour? You were telling you are fully prepared. It is not that when something court is asking, then give half hour, I will come back again. Other people are also waiting. You ask your IO. Ask your IO.
With your permission, I would like to take a call.
Outside the court.
Yes.
Accordingly, whenever they came, they inspected the material. If they found any defect, that we have called and thereafter only it is applied. And that is undisputed fact and that is also admitted by them in cross examination. Main reason for rejecting my suit by the learned trial judge, that you shall find page number 23 of the impugn order. Page number 23, para number 40. When it was the case of the original defendant, that they have paid some amount to one of my vendor directly, and that amount I have not given credit in his account. In that regard, the learned trial judge have given the opinion. Thus, in the oral appreciation of the evidence led by the parties, it is emerging that the communication was made to the defendant by the plaintiff, communicating that with request to transfer of rupees 2 lakh to Shri Gayatri Galvanizer, that this is my vendor, Your Honor, directly on account of advance on behalf of the plaintiff. Exhibit 43 email and Exhibit 45, wherefrom it is clear that the amount of rupees 1,97,680 was paid to Gayatri Galvanizing, and over and above further amount of 6 lakh was also paid to the Gayatri Engineering. Thus, the amount paid by the defendant on account of plaintiff is not adjusted in the ledger account. Therefore, the plaintiff has fallen short to prove the issue of supply of goods as per condition of the condition, and the account is also failed to prove their claim of the acknowledgement of the receipt and goods supplied as per order. And further, the amount paid on behalf of the plaintiff to the Gayatri Galvanizing is not shown as accounted with the final account of the bill against the defendant. Therefore, in the opinion of this court, plaintiff has not succeeded to show and prove that the amount claimed in the relief is proved against the defendant, and therefore issue number 1 and 2 deserve to be answered against the plaintiff. In this regard, Lordship, I request this honorable court to turn to Exhibit 20. Exhibit 20 is my statement of account, Lordship. Whatever the total amount which is narrated in para number 14, Lordship, that is coming to 9,97,680. Lordship will find on Exhibit 80, I have given due credit of that amount. That amount is duly reflecting in my statement of account, that whatever the amount was paid by defendant directly to my vendor, that I have given the credit. And after adjusting that amount only, the amount as claimed by me is due and payable by them. So, learned trial judge, Lordship, they have failed to appreciate this fact and given wrong finding against me, and which is contrary to the recording. For the honor, the defendant in his cross-examination, they are coming with the claim that there was a delay in supply of material to them. But in cross-examination, I have asked him question whether they have filed any claim against me. The answer is coming in negative. They have not filed any claim for alleged delay if they have suffered any losses due to delay. As far as the material is concerned, they are admitting that material is supplied only when it is approved by their vendor. So they are not disputing any of my invoices. Further, defendant is a private limited company. If they are coming with the case that they already have paid entire amount to me, they ought to have produced their statement of account. They have not produced their statement of account at all. Even. Therefore, in my humble submission, Lordship, the trial court have committed an error in appreciating the evidence on record, and they have wrongly dismissed my suit.
But the evidence is to the effect that you had sent lower quality of goods.
Lordship, they are coming with the poor quality of goods, but in cross-examination, they are coming with the case that goods was required to be supplied to Bhava Atomic. They have to come and inspect the goods. If they are finding it in order, thereafter only I have to dispatch. If they are stating that galvanizing is not proper, it is required to be more thick, I have to get it in that order, and thereafter only they will be picking the goods. So no question of poor quality of goods arises here.
The goods are accepted by them.
Lordship?
Goods are accepted by them.
Yes, Lordship, they are in cross-examination, they are admitting this fact.
They have not returned it back. Goods are not returned.
Not returned back. અને સાહેબ એમની જે ક્રોસ એક્ઝામિનેશન છે એક્ઝિબિટ 60 એ વાત ખરી છે કે અમોવાદી દિવ્યા રોલ ફોર્મને જે ઓર્ડર આપેલો તે માલ ભાવા એટોમિક રિસર્ચ સેન્ટરને આપવાનો હતો. એ વાત ખરી છે કે જે માલ તૈયાર થાય તે માલ ભાવા એટોમિક રિસર્ચ સેન્ટરના માણસો આવીને ઇન્સ્પેક્શન કરતા હતા. એ વાત ખરી છે કે આ માલ ભાવા એટોમિક રિસર્ચ સેન્ટરના માણસો એપ્રુવ કરે તો જ મોકલવાનો હતો. એ વાત કરી છે કે તે માલમાં કોઈ ડિફેક્ટ આવે તો ભાગ્યે તે ડિફેક્ટ દૂર કરીને ફરી ઇન્સ્પેક્શન કરાવી એપ્રુવ થયા બાદ માલ મોકલવાનો હતો. એ વાત કરી છે કે આમો કોઈ નુકસાન વળતરનો દાવો ખરાબ માલ અંગે કરેલો નથી. એ વાત કરી છે કે દાવો કરતા પહેલા
We'll hear the other side also. You know Mr. Malik, the respondent, you know about respondent.
he is coming in this matter only. Trial court he was not.
So you can just contact him and ask him to come, Prince, so that it can be heard, otherwise it will get delayed.
Lordship, I'll try.